Joining us here on Condo Solutions. It's Monday morning, 10 o'clock. We answer your questions about condos and HOAs, some of the things that you may wonder about. Maybe you're new to condos here in Florida or homeowners associations in Florida, or maybe you're on the board and have some questions about some technical issues. We're here for that. My name is Mark Breckbill. I'm a local CPA and a member of the Florida CERA Committee, which handles common interest realty associations, condos, HOAs for the CPAs in the state of Florida. And along with me is Peter Mullengarden. Peter's an attorney with a specialty in condominium law and HOA law. So he's here to answer those questions. Been practicing in this area for 40 years. I don't have quite that many, just about 20 to 25. But and we've been doing the show here for about 16 or 17 to help out. And it is a community service program, so you can call in. The number is 772-220-9788. That's 220-WSTU. And you can call and ask your question. We welcome any kind of calls. There's only a few ground rules. One, we ask that you give us a name. Doesn't have to be your name, but we do have to have a name. Second of all, we ask that you don't give us your association name. And the reason for that is twofold. One, the other people out there may hear the association say, well, that's not mine, and so not pay attention. And it could be that that's the answer that they were looking for, because some of these problems, and many of them, are very similar or the same across associations. So that's one reason. The second reason is if it is a client that maybe I have worked on in the past, or Peter's worked on, or it's uncomfortable if we really can't get into discussions on that. But if it's just a generic question that comes in, we can certainly answer those questions without any problem. So that's one of the caveats. We ask for a name and no name for the association. The second thing we always warn you about is we're going to answer the question the best we can, which means that we're going to try to provide an answer based on the law and common practices, statutes, rules and regulations, things like that. But we don't have all of your documents. We don't have your rules and regulations. We don't have your articles and bylaws. We don't have your docs. And so therefore, we can't give you a hard and fast answer that you can go to court with, because your docs can change the answer legally. So if you are in a situation that you're trying to get an answer because you're pursuing legal action or are in the midst of legal action, please recognize that we can't give you that advice without and we don't have your documents. So if you need an answer there and you don't have counsel, you can give Peter a call, and he'll sit down and go over your documents and look at what you've got, and then advise you based on your specific circumstances. So for that reason, we give you what we call radio answers, which, like I said, is the best answer we can give you without your documents, and we'll try to help you through it. But most of the time, it is the issues are pretty standard, and a lot of the practices and rules and regulations are pretty much the same. We have a lot of very, very good condominium and homeowners association attorneys in the state of Florida, and so a lot of them, like Peter, are been dealing with HOAs and condos for years and stay on top of the law and know what they're doing. And so for that reason, a lot of the documents are written such that you can feel comfortable if you've had your own attorney do them. Now, I'm going to say, kind of sounds like backing away from that, but I'm going to say the second thing is that many associations, including some of them that are out there right now listening, are currently under developer control. And so the documents may be written well, but they may not be written the way you want it as a homeowner. In a developer control situation, they have different goals than you do in a homeowners association that's turned over, or a condo association that's turned over. And so therefore, even though the documents, like I said, may be written legally well, they may not be written the way you like them and want them. And that's why we always talk about that on the show, is that when you do turn over, you should take a look at your documents and see if there's language in there that you're no longer comfortable with now that you have control of the association. and make sure you look at that. And if and that's the kind of thing too that give a call to somebody like Peter, and he'll come in and help you look at those documents, and even before turnover, we'll help you look over those documents and potentially give you some guidance. Anyway, that's the basic gist of our show and what we try to do here. We talk about a number of subjects on the show. We will talk a little broader about an issue if a question comes up. So we ask that you be patient if you're waiting, and we're finishing up with another caller. Then please, just be a little patient so that we can get their question answered, and maybe some other listeners who had a similar problem. But otherwise, if Peter and I are discussing a subject, you have a question, and even if it's not on topic, feel free to call, and we'll be happy to take your call. Again, 772-220-9788, 772-220-WSTU. So, good morning, Peter. How are you doing this morning?
Morning, Mark. I'm well. Good. How are you?
Good. It's been, I noticed that it seems like lately there's a lot of stuff going on in the condo and HOA world relative to operations. I mean, we've got a lot of people here still, which is kind of surprising. We have, and of course the question is, are they going to stay here, or are they just waiting a little bit longer before they go back to wherever they go back to? Now, I have heard this last week, I heard some people, heading back, but that's kind of been a surprise, because it's seems a lot more crowded, at least up here in Martin County and St. Lucie County, than I'm familiar with at this time of the year. And also we've got insurance quotes coming in, and it seems like insurance costs have gone up a little bit. We have the hurricane season getting ready to start. We've already had a named storm, which I would say is unusual, because the season doesn't start till June 1st, but I think this is 7 years in a row we've had a named storm before June 1st, maybe 8. So it's not unusual, I guess, to have a named storm, but we got one already. And I think a lot of us, based on last year's season, are a little skittish. We're being told that it will be an active season, but not as active as last year. But then again, I don't think they predicted last year that it was going to be as big as it was. So this time of this season, it's pretty hard to determine how many storms we're going to have. But it is something to look at. We've talked about checking your insurance, making sure that if you need to get something done, that you get it done now, because you could be in a lockup period where you can't change things. And also, you may need to get quotes this year, because some of the insurance companies have experienced damages and have raised their rates. So it may be a time for your insurance agent to take a look at that. Before I leave that subject, I just want to mention one thing about checking rates on insurance. And it a lot of times people think they're going to call up 3 agents, and that's how they're going to bid insurance. And in my opinion, having been involved in insurance, insurance processes for some number of years, if you're talking about a large insurance policy, particularly one that relates to, wind and flood, and or whatever those cases may be, but a large policy, even a liability policy for an association or a business, not everybody writes those policies. Not every agent has coverage for that, or has more than one coverage for that. So the way in general that the insurance industry works on that kind of thing is if I call an agent, and that agent may have 3 carriers, and they may have a primary carrier that they use a lot, that because of the volume of work they do, they get a pretty good discount with that insurance company. But they may have 2 other insurance companies that they do business with occasionally, maybe as a backup, but they do business with them and they can write that insurance. And so once they've put that quote in with the company that they as an agency probably write the most with, and the other two that they don't, it has locked up that quote for that insurance company. So now if I go to a second insurance agent, and that insurance agent maybe doesn't write much of the insurance that the first agent writes, but writes a lot of the other two, and as a result is able to get a much better price for that other policy, they're not going to be able to get that policy because the insurance company has already quoted that insured to another agent. All right. So in effect, your chances of getting the best policy just got eliminated. And so you get three, and you think you've gotten three, but you haven't gotten three of the best quotes because it's the insurance company. So you may have only got one insurance company. In fact, all three of your agents may have gone to the same insurance company, and end up with a situation where all you really did was get one quote, and it wasn't even a good one because the agent that you went to first doesn't write as much of insurance with that particular agency or with that particular insurance company. So the key on insurance when you're trying to get insurance, particularly in areas with high risk like we're talking about, is to utilize a broker. Now, agents can be large enough that they're of the size that they have the choices of a broker. And we have a couple of them around here that are that size, but most of them are not. Most of them are not brokers. So what a broker does is a broker goes out and that broker has relationships at a wholesale level with all of with a number of insurance companies and a number of ones that specialize in certain industries. And that broker goes out and bids those agencies on your behalf to get the best policy offer from each one of those insurance companies. And because of the wide selection that they have, they're able to get the maximum discounts, and they won't get shut out by someone who doesn't because those people aren't involved. So yes, you've only got one agent or broker, but that agent or broker is getting you multiple quotes. And that's the key, is that you should get multiple quotes from that particular agent or broker so that you know and you can make a decision based on the coverage and everything else. The other thing that comes into play here is that if you go through a person who's knowledgeable in this industry, they can compare apples to apples. So let's say I go to an agent and an agent doesn't, and the agent I go to doesn't do a whole lot of condo work. And so as a result, they write commercial insurance, they have commercial agents, but they don't do a lot of condo work. So they go in and get a quote, and maybe that quote doesn't cover all of the risks that it should, or maybe it covers things that are not necessary. Regardless, that quote to that insurance company from that insurance company is going to be different than a quote that another agent puts in with a different set of underwriting criteria, with a different set of facts, because maybe that agent knew a little bit more about coverage in the condo and HOA world, knew you're supposed to have this, you don't need to have this, you need to cover the condo needs to cover common area stuff and things like that, so that they are bidding the same thing. They're bidding apples to apples. And that's important as well. And that's why it's better if you've got a uniform bid process, you know exactly what you're looking for in a policy, and then you allow one person to go out and shop the insurance companies, not shop the insurance agents. And that's the problem that I see many times, is associations try to shop the insurance agent, and they should be shopping the insurance companies. Anyway, so I just wanted to mention that because it's confusing, because sometimes in HOAs, in condos, we think that we have to put everything out for bid and that we have to take the low bidder. Well, we don't. And especially in an area where, especially in an area where there's a specialized knowledge, uh, we are not required to necessarily have three people or three agents or whatever the deal is. And that may be self-defeating. It may not do what you want it to do. Anyway, so that's just some comments I had about insurance. Peter, did you have anything on that you wanted to add to that, or any comments you want to make? I know.
Well, I mean, you have to get competitive bids, plural. You don't have to take the lowest bid. You don't have to get three bids. People tend to forget. They think you have to get, I guess people in their mind think three is like some magic number with bidding. Obviously you should get as many as you reasonably can, but statute just says plural competitive bids, unless it's an emergency or it's the only source of that good or service in the county. But I get asked all the time, whether they need 3 or 4 or 5 bids, and you don't.
Yeah, I think there's a lot of confusion there, and like I said, there's also, it's a question of who you're getting the bids from, and I think that's an issue too. Is that, like I said, many times you're getting the bid from 3 agents, but those 3 agents could be shopping it to the same insurance company, so you really aren't getting 3 bids or 2 bids from the same insurance company. You're getting only one. Even though you have 2 agents that are quoting you. So anyway, so that's kind of that's always a problem. I think that's always something that I've seen. And I know this time of the year, as people are looking at insurance, it becomes an issue. So I wanted to mention that, and let people know. I know too that, for those associations that are employing people, and have workers' comp issues and other related issues. I think that we've seen some of the problems that occur when you try to do some of these things yourself instead of outsourcing some of this work, because if you're a small association, you have 5 people that work for you, or maybe even 10 people that work for you, and in your association, and one of those parties there gets hurt, your workers' comp costs are going to skyrocket, um, and it's going to cause you to have significant costs getting into the JUA pool, 200 to 300% of what the standard rate is. By the way, in the workers' comp area, as you know, the rates are fixed. In other words, what the amount per category is fixed. What's not fixed is what's called the modifier, and that's your experience modifier. That can be anywhere from 70% of those rates, or I don't know, maybe it can be even less than that, but I've seen it as 70% of those rates, up to 300% of those rates, depending upon your experience. And if you're a small and you have one claim, and that claim represents 10 or 20% of your total employees, and then actually maybe more than you've paid in insurance in the last couple of years, depending on the type of claim, it can really significantly increase your workers' comp. And at that point, you can't take advantage of avenues that you would normally take advantage of, like employee leasing, which can get you a more stable and a lower rate. Instead, you're stuck, and you may be, like I said, in the JUA pool. And so you don't want to, you want to be very careful of that. You want to look at diversification. One of the problems that we're having right now is that associations don't understand all of these new COVID rules that have come out relative to employee retention credits. And frankly, as a CPA, it's hard for me to keep up with it, because I'm not primarily a payroll processor. I'm a CPA. But but the payroll companies, the leasing companies, they keep up on these things, so they know what's out there. Now, some of them don't want to sign off on paperwork because they don't want to take a position that they think they're taking a position. But it's important to know and have people that know this kind of thing, because there's an opportunity to miss out on funding. For example, the employee retention credit provides a better benefit and can provide a better benefit uh, as the PPP loan did. And they're now not mutually exclusive because the law changed. So you could have a PPP loan and the employee retention credit. So that's something you need to talk to your payroll processor about. If you're processing your own payroll, you may need to, talk to your CPA or somebody who has some knowledge in this area, because it is, it's something that there's reports that you need to fill out. And there's ways that you need to claim this credit. It's actually refundable. So it goes with your 941. So if you've got somebody doing your payroll that's just doing it on QuickBooks, they may not be up on all of this, and they may miss out on these credits, which are, like I say, they're refundable credits. The credit for 2020 can be up to $5,000 per employee, and that is per quarter that you meet the requirements. And for 2021, that number can be $7,000. So you're talking about an additional $12,000 per employee that you might be eligible for, depending upon how much they make. So that's something to take a look at, and it's a reason that personally I recommend, and I know many times my son's company recommends using an employee leasing company, because they have quite a bit of expertise in this area, and they take a lot of this payroll and human resource responsibility, not just the payroll, because a payroll processor can do that, but also the human resource issues. For example, there's we had a lot of things that came up here recently as to what to do during COVID, what kind of things, what kind of restrictions you could put on employees, what you could do in terms of benefits or termination or whatever. All of these human resource issues that have come up, uh, it's most associations don't have an HR department, so it's kind of nice to have that resource to fall back on, to have somebody like a leasing company that you can go to and ask questions with, and get information on. And like I said, depending upon what's going on, they actually can save you money in the insurance area and in other areas, unemployment, and in other areas which are now skyrocketing. So take a look at that and see if that may make sense for you. And if you need information about it, you can give me a call, 772-631-4800. And I'll be happy to maybe answer your questions and see if I can direct you to somebody that could give you some information. But it's becoming more and more important, and there's other things that the leasing companies can give you guidance on. For example, um, they can talk to you and give you help with harassment claims, whether it be sexual harassment claims or any kind of age discrimination claims. They can help you with what to do if you're worried about that, or they have insurance that they can cover you in certain situations. So a lot of those things that we just don't think about in the human resource area, because you don't do that on a regular basis. Maybe you've never run a company that's had employees. It's There are a lot of those issues out there that need to be addressed, and they help you address those, because they're legally liable if you do what they say, and uh, and it ends up in a problem. They're liable for that, because they have a co-employer relationship. So as long as you followed what their steps were and didn't go off on your own, you can at least get them to share. But in many cases, they're responsible for the activity. So that includes making payroll tax deposits and all of the other things that have to be done. So it is. it's good if you've got that kind of, if you've got them there as a support. One of the things that's going to be interesting going forward is support relative to what you can do under the CARES Act and under all of the revisions to the CARES Act, and now under state law relative to asking people about COVID, whether they've had it, whether they've got it, whether they've been vaccinated for it. I think, and I know that we've we've had word come out from government that you can ask about this. You can ask somebody if they've had COVID. You can ask somebody if they've had the vaccine. Um, in the state of Florida, I'm not sure that's the case. Constitutionally, I'm not sure that's the case. I know HIPAA laws do provide protection. And so when somebody comes in for a job interview, I can't ask them, do you now or have you ever had HIV? And everybody knows that. But for some reason or another, I can ask them if they had COVID. So, think about it a minute. All of this stuff has kind of been through the court system. This isn't new. It's kind of the same. It's a health issue. There's going to be restrictions on what you can ask people about their health. They have a right to privacy. But anyway, so we'll see what happens there too. But it would be really good to have guidance, or someone at least who's going to take responsibility if they do it wrong. So if somebody's told you in writing, yeah, you can do that, and they're your leasing company, then if you get sued for it, you can turn to those guys and say, well, wait a minute. You told me in writing that I could do this. So, and so that gives you some at least help in the legal battle, because you may have to fight it for a long, long time, a long way up. So anyway, those are some of the things that are going on. And then I guess the other thing, Peter, is that we talked about it. I guess the governor's notice, his emergency order is still in effect for this through, what did you say, till June?
It's June 27th or 28th.
Okay, so about another month, and
Mhm.
and so as a result, we have, at least I think most of the attorneys believe that we have still emergency powers that can be utilized, to dictate to the unit owners what they can and can't do. Correct?
Yes, although honestly, it isn't crystal clear. The state of emergency is in effect, so that is the trigger, that is the threshold to have the emergency powers. But you still have to be taking actions under those emergency powers that are justified, right? So, based upon advice of, whether it's experts or whatever, depending upon whether you want to keep facilities closed or how you're treating guests or things like that. So the emergency powers is the threshold, but that's not carte blanche necessarily. There's still other factors that come into play, um, on that. So uh, now it's probably more difficult than ever. Can you still have Zoom meetings only? Right.
Right.
I mean, now we have people being vaccinated, and supposedly, the latest CDC is people who are vaccinated can pretty much go where they want, right, without masks. I mean, that might be an overstatement, but
No, that's pretty much where they're at.
but so, are you allowed to have a meeting now with a Zoom option, or do you say, it's if you're vaccinated, you can attend in person. Yet here in Florida, we can't require vaccine passports. Only vaccinated people only. So it's still a little confusing, to be honest. I think at the bottom line, with the emergency power still in effect, yes, associations, arguably still can impose restrictions that they believe are necessary for the health, safety, welfare. You just have to justify it.
Yeah, and I think it's going to be a tough time for a while here. I think all over, but I think in Florida as well. But because there's we're at that point where it's a lot of people in Florida uh, uh, are pretty pro individual rights, and they may do something, but they don't believe maybe that the government can tell them to do stuff, and or should tell them to do stuff. So it's going to be kind
Yes,
of
but it's also the government's role to keep people safe too. So, you know,
Uh,
that is,
well, yes and no. I'm not sure the Constitution. It talks about keeping us safe from invasion and things like that. I think that's the kind of safe that we were supposed to be safe from. I don't think we're
depends.
supposed to be safe from ourselves, but that's a discussion we'll
Well,
have.
public health is not. Public health is public health.
Yeah,
Anyway,
but
I mean,
but
there is a Supreme Court opinion like 1905 that upheld mandatory vaccination.
really,
So it's over 100 years ago. Um, it was from
was
Massachusetts.
that when they were doing the polio vaccination on, and they tested it on monkeys, and then they decided that didn't work, so they decided to do it on children? Is that the government we're talking about? But anyway, that's just I'm just teasing. But I am the government sometimes is not our friend, I don't think. But anyway, but what I'm getting at is that I do think that it's going to be a tough situation because we've talked before about associations, and when you move into an association, you give up certain rights, particularly in a condo association. You give up certain rights. You give up rights to sole use of certain property. You give up rights to do what you want with your property, and it's no longer the case that you're the king of your castle. There's more of a Knights of the Round Table concept, and so therefore you don't have the ability to just do whatever you want to do, and that's that's contrasted with the belief that a lot of people have that they have the right to do what they want to do as long as it doesn't hurt somebody else. But and their individual rights, particularly in their home and on their property, which is not true in many condo situations. So we're going to have some conflict here, and we've got a lot of new people to the party too, because we have had people who have moved to Florida now from places where their liberties were restricted to come here because of some perceived freedoms that they have, and it's going to cause issues. I think. I don't know about you, Peter, but I think we're going to see some conflict coming because just because of where Florida is and what Florida is in the process, and the number of people that are coming to Florida for the very reason that they feel like they have more rights versus the government. So it's going to be interesting to see what happens over the next few years, really, as the landscape changes. Like I said, it seems like there's a lot more people here now after the season than there was in the past. So I don't know why that is. I don't know if it's people aren't going back. I don't know if I saw where uh, West Virginia I think is the only state that actually lost uh, had a net loss of population. They're actually going to lose a seat in the House because they've lost 59,000 people, and they say that some of that has to do with, I guess, people moving out to work remotely, and now are not coming back. So it's going to be interesting to see. There's going to be some fairly significant changes, and in our industry, uh, there's going to be some conflict because a lot of people bought stuff without really looking into what the requirements were, the restrictions were, and so it's going to be interesting to see what kind of conflict. It's probably things that we've dealt with previously, but a lot of new homeowners haven't. They don't, they aren't privy to the rules or didn't understand the rules when they bought in. Because so many homes I saw in the paper today, and I think in Martin County, it's 12 days to contract, is what they're talking about now. I mean, that's crazy. There's no way anybody's doing any real due diligence if a property is being listed. It's under contract within 12 days and closed within, I think it's closing within 40 or something like that, or less. So it'll be so there's going to be a lot of people coming back, and I know in the property management business, I'm sure it's true for other property managers. We're spending time educating people that now are owners and didn't know what they bought. Fortunately, for most of them, they're still okay with it, but they don't fully understand whose responsibility it is to do what, and who's and what you're restricted from doing, and those kind of things. And it's tough because you've got to explain to somebody, and they're upset because they don't understand why they can't do that, and they don't realize what they bought into. So anyway, it's kind of interesting. We're going to see, I think, a lot of change, or at least a lot of potential conflict coming up. So we'll see what happens. But otherwise, any other things of interest, Peter, that you wanted to bring up this morning?
No, other than I think we'll be able to do our statutory update, legislative update after Memorial Day. So probably the weekend after Memorial Day, which is this weekend, if I recall correctly.
Yep.
So, but we have to check with you, obviously, too. But that would be.
So you're talking about starting starting that first Monday in June is what you're talking about, correct?
Yes.
Yeah. So that sounds good. I think,
and it's kind of interesting. There are some new laws. I mean, I'll give you a sneak peek. But it's interesting how laws get made. Oftentimes, it's because what happens to legislators in their personal lives.
yeah, right.
Translates into a new law, right? Because something happened that adversely affect them or whatever. So I'll just give one little, I guess, preview for the three statutes: the homeowner, condo, and the co-op. Assuming the law becomes effective in July. In each one, before you can charge any attorney's fees on a collection of an assessment, you have to actually do a first or a pre-notice. I'm not sure what we're going to call it, but it has to send out a 30-day notice, basically. And the letter is the form of the letter is going to be in the statute, requesting payment of the assessment plus interest plus any late fees that there may be entitled to, but not attorney's fees. Okay. So that letter has to go out, and then the secretary, officer, or an agent for the association signs an affidavit that letter went out, that 30-day letter went out. Otherwise, that creates a rebuttable presumption that you did the 30-day letter, the first 30-day letter. So on top of the other two notices, the one you have to do before you put the lien on, and the one you have to do before you foreclose a lien, now there's a third notice that goes out. So this will slow things down. And apparently what happened is some legislature got hit with, having to pay attorney's fees or late fees and, whatever. Felt that wasn't fair.
Yeah. Yeah. No, it
creates this other, which I think, quite frankly, is superfluous and slows things down even more than they already are. But that's just interesting how law gets made.
Yeah, it is. I mean, and that is the case. I mean, we've had situations in the past where the where we had a lot of issues with things like this, and they were all because a small handful of association members or politicians plus association members saw a huge problem that didn't exist and immediately smashed it with a hammer when it was an ant. It was one of those kind of things. You took a sledgehammer to an ant, and we see that all the time. I think, frankly, that's probably why the last couple governors have not been very excited about passing laws that, because it's hard for them to tell sometimes when the law that's being proposed is one that makes sense because they're not experts in the field, or or if it's just something that's being proposed because of some congressperson backed up by some lobbyist, and that's trying to get trying to get something changed for their own benefit. But yeah, that's going to be that's kind of interesting. It's
Yeah, I'm not. Yeah, again, I'm not saying that it's the end of the world. And, and it does have its own positive, I guess, impact. I mean, before you can charge attorney's fees, you have to do this other letter. Uh, but if your attorney's preparing that letter, you can't pass that cost on. So that's going to have to be done by if you want. I guess you can have your management company do it, or you do it in house. Just make sure you do it right. So it's but also just seems to me just extends the time, because now we have just more time before you can actually get to the meat of your collections. But they also, by the way, speaking of,
it's also one more item where the attorney is not going to get paid, and the property manager is, because you're right. What's going to happen on these things is that the association is going to probably go to the property manager and say, we need to issue this letter. So the property manager is going to come up with a form letter or something and they're going to send it out, and they're going to bill separate for it, probably similar to the, estoppels and everything else. So they're going to get paid. But if the attorney did the exact same thing, they wouldn't get paid. So that's kind of interesting.
They also, speaking of time, again, this is another sneak preview. Again, assuming this becomes law, I always have to say that now, because these things are not law yet. But for whatever reason, we had this dichotomy or this split between the condominium and the homeowner association regarding the length of time of the letters that were already required. The notice to lien and the notice of intent to foreclose.
Mm-hmm.
And in condo, those letters had to go out 30 days in advance, and an HOA was 45 days in advance. Okay. Well, condo has been increased now to 45 days, just like HOA. So those letters, which I guess doesn't make sense. I never really understood why you had different time periods under each statute, but you did for several years. But now the intent to lien letter for condos is going to be increased to 45 days in advance, and the intent to foreclose letter is increased to 45 days. So, without getting on Allison's, when she's going to be here, doing this, stepping on her toes, I just want to highlight those a couple things. I thought those are interesting.
Yeah, that's
and that's something that affects everyone listening who does any kind of collection work, and I think collections does affect everyone at some point in time. Some associations, fortunately, don't have too many, but it is something that is going to affect everyone usually at some point.
Well, it's going to be a big issue coming up in the next year, probably, because as many of us know, the interest rates are probably going to go up, and the price on houses are going to come down, and so you're going to have situations where people bought these houses at really inflated prices, and are going to be faced with maybe mortgage payments and other things that they can't afford anymore.
Well, hopefully we won't have the, what was it, the 05, 06, whenever.
07, 08, yeah, 09.
07, whatever it was, 07.
Mm-hmm.
The upside down cake world that we were living in. What I've read, banks supposedly are doing a better job of making sure they're qualified, to buy these properties, unlike, it was 14, 13 years ago, whatever, when, people were buying places they really could not afford.
Well, I hate to bust your bubble, Peter, but they're not. I mean, you can still borrow with 3% down. So, and you can still borrow with 10% down and have no PMI. It's
well, I guess I was just hoping it was.
Yeah, I know everybody is, but they don't really, nobody actually looks. So, but it's nice to say that, but it's actually, with all the online stuff that's available, it's become very clerical and mathematical. And so all you have to do is meet the numbers, and there are still tons of exceptions out there. Plus there's a fair amount of private money out there that is in the residential world. It can't be used for your primary residence, but it can be used to purchase other types of residence, like second homes and investment property and things like that. I use quotes, air quotes on that one.
So you think we're looking at another potential
Yeah,
mess that we had before?
right now, primarily the way I always tell, and I think is a good indicator, is you look at the income approach to residential property, which nobody does really because you don't have to. But right now, you're up where a standard home in a standard, middle class community, to rent that, you're talking about $3,500 a month. So who can afford that? I mean, the job market can't afford that. So at some point, those rents have to come down,
Right.
which means that you can't afford, which means the investors can't be in the market. And the investors still are 25 to 30 to 35% of the market. So when you pull those investors out because they can't make money at it, the price goes back down to what they can make money at. And that's well below, I mean, you're talking about I've got a new person that I hired, and they're coming in from out of state, and they are on the rental side. Now, this isn't on the buying side. They could actually probably buy but on the rental side, you have to have three times they're looking at three times the income over the rent. And minimum on a 2-bedroom apartment now is about, up here in Martin County, is about $1,600. So, you're talking about, what's that? Almost $5,000 a month, almost $60,000 a year to lease a 2-bedroom apartment. So you think about how much of the market that cuts out. But on the buy side, that's as little as 25%. It's, as little as 25% that you have to have, a loan to, or income to housing costs. So anyway, it's kind of interesting that that's out there, and that dichotomy is out there right now. And and so the other thing is that if interest rates go up by say 1%, long-term 30-year rates go up by 1%, it actually affects the value of your property by about 10%. So, you get a 3 or 4% increase up to around 5 or 6%, and housing prices would drop pretty considerably. So anyway, it's going to be interesting to see what happens. I think associations are going to be looking at some of these issues. So I think it's be good to talk about this. And then, so we'll be talking not next week, and I'll be gone next week, but the week after that we'll be back, and I'll also probably be gone that Monday. But we'll let you know. We'll figure it out and get back with you. Peter, thanks for all of your wise advice, and thank Allison for filling us in. And we'll see everybody next Monday from 9 to 10 o'clock.
Weekend, everybody.
Yep. See you later.